Hi, Kerry. Thank you very much for joining me.
Pleasure.
It's an honor to have you here again.
Thank you. Good to see you again.
I've been following you and I've been reading your newsletters and your talks about these new cases, interesting stuff coming up. And not
Yeah,
many people are aware of them, Even in the legal tech talk, I mentioned a couple of these things, and not many people, even in the industry, are aware of them, and they are very, very mind-blowing and very important for the industry. So that is an opportunity for me to get your perspective on this and then share with our audience, and if there are some
one of
interest.
the things on that, there's obviously benefits in the availability and speed of information. For example, that law reports now are posted by the courts. Court of Appeal will put their judgments on when it's delivered. But it's a bit like television in the old days. There are only 3 channels or whatever, and everyone would, a big program, people would be chatting about at work the next day. Now there's hundreds of channels, you watch them at different times. And I think it can be a bit like that with legal information that, I mean, the Mazur decision, I have seen, without exaggeration, hundreds of different commentaries and so on. Some of them, how should we say, informed. So
This is really important. So what are the main issues here? If you can summarize it in like 2, 3 minutes, the main issues and what is the judgment and what are the implications for the industry?
I think the judgment is less significant than many people are making out, but broadly, this stems from the Legal Services Act 2007, and the issue is who can do what in a litigation case. So we have reserved activities which are reserved to lawyers in the broadest sense, and again, broadly, that's the conduct of litigation, probate work, and certain aspects of conveyancing. And traditionally, by that I mean historically before Legal Services Act 2007, anyone in a law firm, and barristers could do that work, whether they were qualified or not. And there were extensive and perfectly proper rules about supervision, so that a partner or a solicitor had to supervise, and the buck stopped with that supervisor. No one's got an issue with that, I don't think. And what the Legal Services Act does is it is arguably the worst written Act of Parliament in history. And if anyone can truly understand it, on one interpretation, it makes a non-solicitor, or in cost cases, cost lawyers can deal with matters, and legal executives with certain additional legal executive qualifications can, but that only an authorized person, I will use the term solicitor, it's a bit wider, can conduct litigation, and that others, trainee solicitors, paralegals, experienced secretaries and so on, can assist, but they can't conduct litigation. And that may be a fine line. Potential impact is in mass low value, for example, debt claims, where there's no law at all, really. It's just a question of so-and-so owes my client money, we want it back. Now, historically, would that have been done by a solicitor? No, it wouldn't. It would have been an article clerk trainee, but it doesn't matter. And that's the issue. And in the Mazur case, ironically, it was litigants in person. I mean, ironically, because obviously they can conduct litigation for themselves without being lawyers, who won. And what had happened there is that they owed, allegedly, money, legal fees, to a completely different firm, not the one involved in this litigation. And that firm, Charles Speechley Russell, they instructed another firm to collect the debt. That other firm then had a person described as head of commercial litigation who was not a lawyer. And the litigants in person said, well, they have no, this person has no right to conduct litigation, and asked the matter to be struck out. The circuit judge, the county court, refused to strike it out and awarded costs against the litigants in person. The High Court refused to strike the claim out because they said that by now it had been rectified. It was being conducted by a solicitor, but quashed the costs order and went on to say that a person who is not an authorised person cannot conduct litigation. Now, the case is there are other aspects to it that clearly the person should never have been described as a commercial litigation. Had they correctly described as a paralegal, that may not have caused so many alarm bells. The first judge got the cost completely wrong anyway. It was a fixed cost case and the cost of £636. He didn't realise that or didn't understand it, so awarded £10,500. Well, I suspect, but I may be wrong, that the litigants in person may not have appealed an order of £636, but the impact operates in different ways. For firms where the work is supervised by an authorised person, I think there's no real problem. One needs to be careful in the client care letters and the retainers to say, well, I, solicitor or qualified legal executive cost lawyer, I'm conducting it. I am assisted by trainee 1, trainee 2, paralegal 1, paralegal 2. Unfortunately, a lot of firms have been conducting cases where a completely unqualified person, it says, I have the conduct of this litigation, and on the face of it, that's a triple problem. One, arguably a criminal offence, that's sections 14 to 16 of the Act. Secondly, that the case could be struck out on the basis that it's being illegally conducted, just as if, I don't know, not being fishmongers or whatever, but or lorry drivers, but it's as though they were conducting it, or indeed that I was driving a lorry and I'm not allowed to. And thirdly, and perhaps more practical significance, is the disallowance of costs. And I've already seen plenty of emails to my solicitor clients saying, we noticed that the email you wrote to our client, or to us, said, I am so I have the conduct of this litigation. You're not an authorised person, we're not paying any costs. So that's, if the case is right, and I don't think it is, I think it's wrongly decided, then the big impact is on ongoing cases. Moving forward, can all but the huge factory firms, they may have a problem. Can anyone else just get their paperwork and systems in order? Yes, they can. I think closed cases, the courts are reluctant to reopen for all sorts of reasons. I think the main practical risk for firms is that matters that they've been conducting, whoever by, they will lose some or all of their costs.
What is the implications for AI in this case? If a paralegal cannot conduct litigation, so what about all these companies who are actually putting together AI that can get involved and do litigation? They are very optimistic about it.
Yeah,
what is the future holds for that?
That's a complete no-no in my view, if the decision's right. Now, prior to the Legal Services Act 2007, as I've said, anyone could do the work under supervision of a solicitor or legal executive or whatever. And of course, the firm is regulated and the principals of that firm are liable for any wrongdoing by, I don't mean that necessarily in a criminal sense, but anything negligent or whatever, improper done by anyone in the firm. Now, the reason I say the decision is wrongly decided, in my view, is that because the Act defines person as a body, corporate or incorporate, as well as an individual. And so the argument is, well, as the body is authorised, then anyone working for them is part of that and can. But if we leave that aside, I think it's clearly a huge discussion. Let's say there only needs to be supervision and not conduct. Can a solicitor, hand on heart, say, yeah, everything's done automatically, for example, the flight refund cases? But I'm supervising it, because the problem then is on costs. You say, right, come to court, we're going to cross-examine you, and your average solicitor, of course, if you say, well, tell me about how you're conducting this AI run case, they wouldn't have a clue. So, and I think it may be, I mean, I saw a bizarre comment by somebody who should have known better, saying, well, it can't be an offence for an AI because it's AI, it's not a person. Well, of course, it can be an offence for the business using it.
Yes, yes, yes.
I think in a funny sort of way, it may end up bringing clarity from what appears to be utter chaos, in the sense that if nothing had happened, we would still have that issue about AI. To what extent is that being supervised, let alone controlled? Now that it's causing an absolute storm here, that will have to be addressed. And it is hoped that when that is addressed, Parliament or courts or whoever will take the opportunity to give guidance on the use of AI in litigation and indeed in probate and conveyancing, which are also reserved.
The issue with AI in legal services, one of the main issues is that, you know, the EU AI Act is the first AI Act that came out, and it classifies AI based on its usage. So basically, if AI is used in a high-risk environment like health or military or energy, it's called high risk. If it is in a very important infrastructure, so it doesn't matter on the application. Any AI that is used in the healthcare, it is high risk. That means they have to go through a lot of compliance before they are put on the market. They cannot just put them on the market an AI application and put it in the health sector. Whereas if an AI application is coming to the legal sector, they don't have to go through any of that. So they don't have to show any compliance to anything. It's up to the law firm and regulators to decide whether or not this AI application is compliant. Maybe some organizations are trying to hide behind AI, which is not possible. They cannot get away with it. With Air Canada case, we heard that what happened, basically a passenger was talking to the chatbot and the chatbot gave the information, and based on that information the passenger acted and lost money and is claiming the money that chatbot promised. But the company is saying, no, this is not us, this was another entity, this is nothing to do with the company. And the court ruled that no, this AI tool that you have used is extension of your company, so it's under you.
That must be right. Now, if someone relies on AI that is not in any way being used by the company, then the company clearly shouldn't be liable. I don't think we'll accept that. And that seems to be a fairly clear line in the sand, that if, it's no different from what I was referring to just now. If I employ a member of staff who then causes damage to a client, I can put it that way, well, the buck stops with me. And that must be the same with AI, because as you've indicated, the end game is just hide behind it and blame something else. I mean, talk about a workman blaming his tools, that's a classic. Oh, I know I've just run over you, but that was my car, it wasn't me.
It's also the other issue is the fiduciary duty, you know. If a member of a staff or a director of a company acts in a way that is not in the best interest of the company, they are breaching their fiduciary duty.
Yeah.
So if AI becomes autonomous and becomes almost as an employee of a company, would AI have fiduciary duty towards the company? You know, where does that stand?
Can an AI program, can it sue for unfair dismissal? Where does it get holiday? Does it get sick pay? And I saw, I think for every lawyer in the land, we're getting maybe 10, 15 emails a week, if not more, from different companies offering AI as the solution to everything. And some of them, I've looked at, actually at that price, I could employ people who will do the job better, personal contacts and so on. I think a lot of it is nonsensical, the assumption behind it, in the sense that is the ability for example, with a Google search to extremely quickly locate information and then check the source of it. For example, if it's Bailey, which is the court judgments website, or the National Archives of the United Kingdom, or Parliament's website, well, that's a perfectly proper source. So to use, where I don't see for a lot of people, if you say this can actually do this and do that, we can talk about that. But as an information gathering tool, I don't see what it does beyond, for example, Google, whereby you can, or other, where you can locate it and say, right, I've got the judgment, that's from the Court of Appeal website. That's fine. Oh, I didn't know that. Well, of course, what AI is doing, and what people are relying on, is they're not going to the original source. They're relying on an AI overview, and hence the what have been termed now the hallucinatory cases and citations and judgment. I think the courts all over the world, certainly in Canada, the United States, Australia, and the United Kingdom, that I know of, are becoming understandably very tough. Now,
the courts are getting quite upset with it, and they are actually threatening that if this continues, we are going to push for criminal charges. What sort of...
And they don't even need to do, I mean, they can do that, but what's called contempt in the face of the court, and putting a false judgment before a judge clearly is, the court can themselves initiate contempt of court proceedings. It's standard, proving the matter beyond reasonable doubt, but it's massively quicker and more effective in that sense. It's not a jury down the line in 3 years' time doing it. It's a judge in a couple of weeks fining, or even committing to prison. Which, would they do that the first time? No, but they've given enough warnings now in various cases, which we've between ourselves, you and I've discussed. And I think now the courts in England and Wales would entirely reasonably say, well, we've had a number of cases where we've made it clear what will happen in the future. They've had extensive publicity. You must know now. It's your duty to check citations and cases and so on. I don't think anyone could argue that. If you throw that into another situation, a surgeon operates in a completely wrong way. It says, well, I looked at AI and it said, actually, you should use a forklift truck to operate on an eye, or whatever, you know what I mean? I don't see anyone can have a problem punishment of lawyers who don't check the sources.
What I wanted to add is actually these LLMs, large language models, they are created to provide a service to the public and to the lawyers alike, and they are treating you as a fee-paying customer. So the algorithm behind it is designed in a way they want to make sure you are happy so that you continue coming back. You know how friendly they are. They always say, do you want something else? Do you want me to do this for you? They quickly give you the response you want. They hardly ever tell you that you are wrong. And recently, actually, OpenAI tried to adjust it, and they realized quickly that the new model that they put out, people don't like it, because people don't like to be told that you are wrong. So they gone back to the original algorithm in a way.
Which is
and lawyers have the same problem. So if a lawyer doesn't understand how this LLM works, doesn't realize that this LLM actually is looking at you as a fee-paying customer. He want to make you happy. It doesn't want to say, oh, sorry, I don't know the source of this. It creates for you. It brings in a source that doesn't even exist so that you are happy. And so you cannot rely on it because of the algorithm itself. So the whole thing is not in a way that you can rely on it 100%.
No, and it's not just that. Even if it was, let's say it was completely accurate, and I think this is a point that is not being thought through. We know it's not accurate a lot of the time, but let's assume it was accurate 100% of the time. Does that actually make everything all right? No, it doesn't. Every lawyer doing litigation will say sometimes quite often the very best advice we give to a client is to say, I can win this for you, don't go with it. For example, neighbour disputes. I probably can get you that 5 square meters of land back. You'd have 20 years of hell with your neighbours or whatever. In other words, if it was able to say, well, here are the facts, here is the law. Actually, for example, a neighbourhood dispute would be interesting if AI said, but in fact, the vast majority of people who bring such cases, even if successful, recognise it's one of the worst decisions they ever made in their life because it costs them a fortune and they end up with unhappy neighbours, with an unhappy relationship. It comes back to the point discussed before, which is it's partly about authority. I don't mean authority in a sort of an aggressive manner. What I mean is that will people ever accept removal of children from their custody or losing their home due to a computer? The answer to that has got to be no. Will they accept it from a judge who has relied on computers? Now, I know it's a fine line because you say, well, what's the difference between that and relying on a law that's written by someone? And so in theory, that's correct. The difference is that I'm sure it's true. You talked about Air Canada. I'm sure it's true in health and energy and high risk areas, medicine, that there are sources that are trusted and reliable, and there are those which are not. And that's very much the case with law, not just in terms of the websites that have, for example, the parliamentary website. Even if it's wrong, it's deemed to be correct. If they've got, just like the old master copied the Act of Parliament, and you're safe. And you have, people who become known as an authority. That is the word. Well, she's an authority on this. He's an authority on that. That's the very word used significantly. Not an expert, so no, she's an authority on